July 20th, 2026. The same day Nolan Wells was laid to rest in Ocean Springs, Mississippi, something else happened, quietly, away from the funeral. Attorneys representing his family sent out letters, 10 pages each, addressed not to investigators, not to the sheriff's office, to Nolan's own friends and their parents. The letters carry a warning most people have never had directed at them. Preserve everything. Every text message, every group chat, every phone, every laptop, every photo. Don't delete anything, because litigation is coming. That's not a rumor. That's a document, obtained and confirmed by name. At the same time, a second report has surfaced, one about Nolan's own body, and a detail forensic pathologists are still trying to explain. This is where the case stands right now. Stay with us. You need the full picture. If you're already caught up on this case, everything new is in the first half of this video. If you're new here, welcome to the Black Docket. Today we're covering the Nolan Wells case, new legal letters, new autopsy findings, and where this investigation actually stands. Subscribe if this is your first time here, and let us know in the comments where you're watching from. Let's get into it. Let's start with the biggest development in this case in weeks, because it changes the entire shape of what happens next. Not in the criminal investigation, but in a track running alongside it that a lot of people following this case haven't fully clocked yet. On July 20th, the day of Nolan's funeral, attorneys representing his family sent what are called spoliation letters to several of Nolan's friends and their parents. These letters were obtained and reported on by Magnolia Tribune, which confirmed multiple friends and families actually received them. Let me explain exactly what a spoliation letter is, because the term itself sounds more dramatic than it necessarily is, and getting this right matters. A spoliation letter is not a lawsuit. It's not a criminal charge. It's not even an accusation of wrongdoing, technically. It's a formal legal notice, typically the first concrete step before an anticipated civil lawsuit, that puts the recipient on notice of a legal duty to preserve any evidence that might be relevant if that lawsuit actually happens. The reason it exists as its own legal tool is simple. If evidence gets deleted or destroyed after a party had a legal duty to preserve it, that destruction itself can become a serious problem for them later in court, regardless of what the original evidence would have actually shown. Here's language directly from the letter itself, as reported. You are hereby placed on notice that litigation concerning the death of Nolan Wells is reasonably anticipated. Accordingly, you have an immediate legal duty to preserve all materials of all kinds within your possession, custody, or control that may be relevant in any way to the claims or defenses. The letter goes further, too, stating that duty extends not just to the recipient personally, but to their family members, and to anyone providing services to them or acting on their behalf. The letters are 10 pages long, and lay out specific categories of material the family is asking to be preserved: text messages, group chats, emails, phones and laptops themselves, social media accounts, photos and videos, and, this detail matters, boat maintenance records and fuel purchase records. That last category is worth sitting with for a second, because it tells you exactly where the family's independent investigation is currently focused. Boat maintenance and fuel records would speak directly to questions that have been part of this case from the very beginning. Whether that documented bilge pump failure was a sudden, genuine mechanical problem, or whether there's a maintenance history that tells a different story. That's precisely the kind of physical, verifiable record that doesn't depend on anyone's memory of a chaotic afternoon. Now, who's actually behind this letter? It was signed by attorney Gary Bufkin, of the Ridgeland, Mississippi-based firm Carroll Bufkin Ploak. Ben Crump, who's been the public face of this case since early on, isn't licensed to practice law in Mississippi, which is exactly why the family's legal team has associated with a local firm to handle exactly this kind of formal legal action. That's a completely standard practice for high-profile attorneys working cases outside their home state. Not anything unusual on its own. Bufkin himself has a track record worth knowing about, since it speaks to the kind of cases his firm typically handles. He represented former Hinds County District Attorney Jody Owens in a Jackson bribery scandal, and separately represented Nancy New and her nonprofit in Mississippi's TAMF welfare fraud scandal. Both of those cases ultimately ended in guilty pleas from his clients. He's also represented a Chinese nonprofit in an unrelated lawsuit Mississippi's state government filed over COVID-19. I'm including that background simply because it's public information about who's now formally involved in this case's legal side, not because it implies anything about how this particular matter will unfold. What this actually signals, practically, is that the Wells family is now formally preparing for the possibility of civil litigation against Nolan's friends and, potentially, Their families, separate and apart from whatever the criminal grand jury process eventually produces. Those are two entirely different legal tracks, with two different burdens of proof. A civil case requires proving something by a preponderance of the evidence, essentially more likely than not, which is a substantially lower bar than the beyond a reasonable doubt standard a criminal case would require. It's entirely possible for a civil suit to proceed, or even succeed, in a scenario where no criminal charges are ever filed at all. I want to spend some time on why this development is arguably more consequential, in practical terms, than anything the criminal side of this case has produced so far. A criminal investigation moves at the pace of a sheriff's office and a district attorney's timeline, constrained by search warrant requirements, grand jury scheduling, and the general slowness of that entire process, all of which we've seen play out over these past several weeks. A civil claim, once filed, operates on a completely different track. It gives the family's own attorneys the power to issue subpoenas, take depositions under oath, and compel discovery of the exact categories of material named in this letter: text messages, call logs, boat maintenance records, through a process the family's legal team controls far more directly than they ever could within someone else's criminal investigation. That's likely the actual strategic logic behind sending these letters now, before any lawsuit has technically been filed. Once evidence like a group chat or a set of maintenance records is gone, it's gone, and a letter like this creates a paper trail. If something covered by this letter later turns out to have been deleted, altered, or lost after this notice was received, that fact alone becomes something a jury in a future civil case could be told about directly, regardless of what the original material might have shown. Legal professionals sometimes refer to the consequence of failing to preserve evidence after a spoliation letter as an adverse inference, meaning a judge can, in some circumstances, instruct a jury that they're permitted to assume the missing material would have been unfavorable to the party who failed to preserve it. That's a serious legal exposure for anyone who received this letter and doesn't take it seriously, regardless of whether they did anything wrong on July 4th itself. It's also worth understanding what this letter does not do. It doesn't compel anyone to hand over their phone right now. It doesn't create any immediate legal jeopardy on its own. Receiving a spoliation letter is not the same as being sued, and it's certainly not the same as being charged with a crime. What it does is start a clock. From this point forward, anyone who received one has a documented, formal reason to know that deleting relevant material could carry real consequences down the line, whether or not a lawsuit is ultimately filed at all. Now let's turn to the independent autopsy, because this is where the medical picture of this case got its most detailed update yet. On July 22nd, at a news conference held during the Knox National Convention in Chicago, Ben Crump announced the preliminary results of the family's independent autopsies. The second autopsy performed on Nolan, conducted by forensic pathologist Dr. Roger Mitchell and funded by Colin Kaepernick. The headline finding: the cause and manner of death remain undetermined. That matches what the state's own autopsy process has indicated as well. 2 separate medical examinations, and neither has produced a public, confirmed answer. But there was more specific detail in this report than we'd had previously. Dr. Mitchell's report described red discoloration in the soft tissue at the back of Nolan's head and neck. Crump was careful, to his credit, to characterize this accurately. He said the finding needed further investigation because Mitchell himself reported that the cause of the discoloration was unclear. I want to bring in some outside medical context here, because I think it's important not to let a detail like this get overinterpreted in either direction. Dr. Kendall Von Crowns, the chief medical examiner in Tarrant County, Texas, who has no involvement in this case at all, was asked to weigh in on what a finding like this can and can't mean. Her explanation: red discoloration like this could represent decompositional changes in the muscle tissue, or it could reflect blunt force injury to the back of the head and neck. Those are 2 very different explanations, and based on the report alone, there's no way to determine which one applies here. That's precisely why Mitchell's own report describes it as inconclusive rather than as evidence of anything specific. There's another detail from this autopsy that's arguably more procedurally significant than the discoloration itself. Mitchell's report noted that portions of Nolan's throat were not present in the remains when they were received for the independent examination. Crump stated plainly that because of this pathologist cannot rule out injury to the neck as a contributor or a cause of death. Not because there's evidence of such an injury, but because the tissue that could have shown one either way simply wasn't available to examine. It's worth understanding why that tissue might be missing before jumping to any conclusion about it. Dr. Priya Banerjee, a board-certified forensic pathologist not involved in this case, explained that second autopsies carry what she called an inherent limitation. A body that's already been through one full examination is never going to be in the same intact state a first unexamined body would be. Retaining portions of tissue like the neck structures for further examination is actually a documented common practice in forensic pathology generally, not something specific or suspicious to this case. The report itself apparently noted as much. Whether that standard practice happened here, or whether something else explains the gap, is exactly the kind of question this back and forth between the two medical teams is meant to resolve. Crump has explicitly called on local officials to share their own findings with Dr. Mitchell so a fuller picture can be assembled. I think it's worth pausing on how genuinely limited this entire report actually was, because it's easy for a headline like "Red Discoloration Found" to travel much further online than the actual caveats attached to it. The body arrived for this second examination already significantly decomposed and already having been through one full autopsy. Mitchell's report reportedly listed 7 separate outstanding questions he simply couldn't answer given what he had to work with, including what led Nolan to enter the water in the first place, whether there was water in his airway, the composition of his stomach contents, and what intracranial imaging actually showed. The report couldn't determine whether Nolan was conscious or unconscious when he entered the water, and couldn't examine his airway or stomach directly because those structures weren't fully available for the second exam either. That's a genuinely striking number of unanswered questions to come out of a formal press conference, and I think it's important to say plainly, this autopsy answered far less than it left open. It confirmed that no obvious skull fractures or lacerations were found. It flagged one ambiguous finding that could mean very little or could mean something serious, and it closed by explicitly asking the state medical examiner's office to share its own findings, because Mitchell's team simply didn't have enough material to reach firm conclusions on their own. Crump's own words at the press conference reflected that limitation honestly. This is only another part of the puzzle, and even though it tells us significant information, we still have more questions than we have answers at this time. At that same press conference, Crump raised a specific factual dispute about how Nolan's body was found, stating that while officials have said he was recovered wearing only swim trunks, the United Cajun Navy had told the family he was found wearing a t-shirt as well. This is where we get a direct, on-record contradiction worth including in full, because leaving it out would make this case sound more one-sided than it actually is. Brian Trasher of the United Cajun Navy pushed back directly and publicly after that press conference. He told reporters, "I observed the body from the air, and he was wearing only swim trunks that matched the photos taken of him that day," and said plainly that Crump had misrepresented what the organization had communicated to the family, both publicly and privately. I want to flag this clearly, the same way we've flagged similar moments throughout our coverage of this case. This is a real, named, on-record disagreement between two credible sources. It doesn't mean either side is lying. It could reflect an honest miscommunication somewhere, in a long chain of conversations between a search and rescue organization and a grieving family working through an attorney. But it means this specific detail, what Nolan was wearing when he was found, is genuinely disputed right now, not settled, and shouldn't be repeated as confirmed fact in either direction. It's worth thinking about why a detail this small, a t-shirt, present or not, has become significant enough for a named search and rescue official to publicly push back on the family's own attorney. Clothing condition can matter to a forensic reconstruction in real ways. It can speak to whether someone entered the water voluntarily and prepared, or under different circumstances. And it can factor into how investigators think about the timeline between when Nolan was last seen and when he ended up in the water. That's likely why this specific detail got included in Crump's press conference at all, rather than being left out as a minor point. It's also exactly why Trasher felt it necessary to respond publicly and specifically, rather than letting the claim stand unchallenged. From his organization's perspective, an inaccurate account of what searchers observed and reported could shape public understanding of the case in a direction their own first-hand observation doesn't support. This is a useful moment to step back and notice something about how this case has unfolded overall. Nearly every major claim introduced by any party, the family's attorneys, the friends' families, outside commentators, has eventually met some form of correction, clarification, or direct public pushback from another named source. The disputed video and quote earlier in this case were walked back by Crump himself. Katie's account and Gracie's account required careful reconciliation, rather than treating one as simply true and the other false. And now this. That pattern isn't necessarily evidence that anyone is acting in bad faith. It may simply reflect how genuinely difficult it is to reconstruct a single chaotic day, weeks or months later, through the accounts of dozens of different people, each with their own partial view of what actually happened. Jackson County District Attorney Angel Myers McElrath has also spoken publicly this week, and her comments read like a direct response to the mounting public pressure and speculation surrounding why no charges have been filed. She stated that all evidence in this case will be presented to a grand jury, which, she was careful to note, is not special treatment or unusual handling for this particular case. It's simply how her office handles nearly every non-natural death. Her exact words, "Every death in the county, except those of natural causes and non-criminal car wrecks, are presented to a grand jury. Many people don't know that. I think that statement is worth taking seriously on its own terms, separate from whatever you think about how this case has been handled overall. It's a direct, named, on-record attempt by the actual prosecuting authority to correct a specific misconception that's been fueling a lot of the "why hasn't anyone been arrested yet" frustration online. Whether or not you find it fully reassuring, it's a factual claim about standard office procedure that can, in principle, be checked against how her office has handled other cases. And it's the kind of specific, falsifiable claim that's more useful to evaluate than vague accusations of favoritism in either direction. There's a reason a district attorney would choose to make a statement like this publicly, rather than simply letting the grand jury process run its course silently, the way these processes typically do. Public confidence in an investigation's fairness is part of what allows its eventual outcome, whatever that outcome turns out to actually be accepted by the community it affects. A prosecutor who stays completely silent while public suspicion builds risks that any eventual outcome, an indictment or a declination to indict, gets read through the lens of that unaddressed suspicion rather than judged on its own merits. McElrath's statement reads like an attempt to head that off directly, by explaining the mechanics of her office's normal process before the grand jury's decision is even reached, rather than after. The reward fund connected to this case has grown. Originally established by the Reverend Al Sharpton and Tyler Perry, it's now been joined by former NFL player Terrell Owens, who's contributed an additional $25,000, bringing the total reward for information leading to an arrest and conviction to $125,000. It's worth being precise about what that reward is actually for. It's explicitly conditioned on information leading to an arrest and conviction, meaning it's built on the premise that a crime occurred and someone will eventually be held responsible for it. That's a real financial incentive now sitting on top of a case where, as of this recording, authorities have said they have no confirmed information indicating a crime was committed at all. That tension, a six-figure reward for a conviction in a case with no confirmed crime yet, is itself part of what's fueling the intensity around this story right now. Separately, Mississippi's Attorney General, Lynn Fitch, issued a public statement warning against threats or intimidation directed at law enforcement personnel working this case. Her office's statement read, in part, "I am proud of the professionalism with which our law enforcement, district attorney, and other local leaders are approaching this tragic case. During an open investigation, it is vital to the cause of justice that everyone respects the integrity of the process. Efforts to intimidate, disrupt, or interfere with the work and threats to anyone's well-being will be taken seriously." This is a meaningfully different warning than the ones we've covered before in this case. Earlier reporting focused on threats against Nolan's friends and their families. This is the state's chief law enforcement officer, specifically defending the investigators and prosecutors themselves. Taken together, it paints a picture of a case where the pressure and hostility online has now touched nearly every party involved: the friends, their families, and now the officials actually running the investigation. I think it's worth naming directly what this tells us about where this case has landed in the broader public consciousness. It's rare for a state attorney general to issue a public statement specifically warning against threats to local investigators in an individual death case. That's the kind of statement typically reserved for cases that have already generated real, documented intimidation, not hypothetical concern. Fitch's office wouldn't have issued this proactively without some reason to believe it was necessary. That in itself tells you something about the temperature this case has reached, independent of anything about the underlying facts of what happened to Nolan. There's also a broader tension worth sitting with here, one that's been present throughout our coverage of this case but feels especially sharp this week. A six-figure reward exists, explicitly premised on the idea that a crime occurred and someone will eventually be convicted for it. A grand jury process is underway, built on the premise that the truth isn't yet known. A district attorney is publicly explaining that referring a death to a grand jury is standard, not evidence of anything unusual. And a state attorney general is warning against threats to the very people tasked with sorting all of this out. 4 different institutions, 4 different messages, all circling the same unresolved question: And all of it happening while Nolan's own family still doesn't have a confirmed answer for how their son died. There's one more thread circulating this week that I want to include, but I want to be very upfront about its evidentiary status, because it's meaningfully less confirmed than everything else we've covered so far. A post circulating on the platform Threads claims that Christine Wansley, Nolan's mother, who works as a family medicine nurse practitioner, has been targeted with a wave of one-star reviews on her professional profile over the past 2 weeks, allegedly timed to when she was away from work following her son's death. The post characterizes this as a coordinated, racially motivated campaign. I want to be direct about what we can and can't say here. We have not seen independent verification of the number of reviews, whether they're still online, who posted them, or what actually motivated them. Neither Christine nor her employer has publicly commented on this specific claim as of this recording. That doesn't mean it didn't happen, but it means treating it as a confirmed, verified fact would be going further than the evidence currently supports, and we're not going to do that. What is separately confirmed and distinct from this specific claim is that Christine has previously said, in her own Facebook post, that anonymous hate mail was delivered to her home in the lead-up to Nolan's funeral. That's a direct, on-record statement from her, not a second-hand viral claim, and it's part of a documented pattern we've covered before, including the FBI's confirmed involvement addressing interstate threats connected to this case. Whatever the full truth of the review bombing claim turns out to be, the broader pattern it's describing, a grieving mother facing online hostility while searching for answers about her son's death, fits within a documented, confirmed pattern of harassment this case has already produced. That context is worth holding on to even while we withhold judgment on this specific, unverified claim. Nolan Xavier Wells, 18 years old, grew up in Ocean Springs, Mississippi. He'd just finished his first year at Southwest Mississippi Community College, where he walked on as a wide receiver, and was due back for summer training camp on July 6th. Independence Day fell on a Saturday. Nolan and a group of friends took a boat trip to Horn Island, a federally protected barrier island roughly 10 miles off the Mississippi coast, a trip this same group had made before without incident. According to GPS records obtained from Mississippi's Department of Marine Resources, the boat left its dock at 9:56 a.m. and arrived at Horn Island at 11:14 a.m. The last confirmed sighting of Nolan alive places him on the island around 3 p.m. At around that same hour, someone aboard the group's boat placed a call reporting a bilge pump failure. The boat was taking on water. That call, later released publicly, independently confirms the mechanical emergency genuinely happened. The boat left the island at 4:31 p.m. without Nolan and returned to its dock by roughly 5:44 p.m. One friend has said Nolan chose to stay behind to talk with a young woman he'd met on the island that day, since identified in reporting as Katie McCormack. Her own account, relayed through Christine, was that Nolan told her his intention to rejoin his friend's boat, though she never personally witnessed him doing so. Other accounts, including one from McCormack's sister Gracie, have suggested Nolan was ready to leave with the group. A former FBI agent who's since reviewed the public record on this case, Jennifer Coffindaffer, has said she believes this is likely more a matter of timing than anyone being untruthful, that both accounts could reflect honest, if incomplete versions of the same afternoon, rather than a direct contradiction. It's worth remembering just how much of this case still hinges on that specific window of time. Every new development we've covered today, the spoliation letters, the autopsy's inconclusive findings, the disputed clothing detail, all of it still circles back to the same roughly 90-minute gap between Nolan's last confirmed sighting around 3 p.m. and his friend's boat departing at 4:31. Nothing publicly available has fully closed that gap yet, and until something does, every other piece of evidence in this case is, in a real sense, still orbiting around that unanswered question. Nobody called Christine that night right away. Her phone rang just after 11 p.m. Not Nolan, but a friend. A call to the Coast Guard that night didn't meet the threshold for immediate deployment. A search stood up the next morning involving the Jackson County Sheriff's Office, Mississippi's Department of Marine Resources, the National Park Service, the Coast Guard, and the volunteer United Cajun Navy. On the morning of July 6th, a National Park Service ranger found a body in the water off Horn Island's northwestern shore, later confirmed to be Nolan. The state autopsy was conducted July 7th. Officials have said there's no indication of drug or alcohol involvement so far, though that finding is preliminary, pending toxicology. Jackson County Sheriff John Ledbetter has said there's no initial indication a crime occurred, while stressing investigators are working to determine exactly what happened, and that his office welcomes the family's independent investigation. One preliminary internal document from Mississippi's Marine Resources Agency, sent as part of the initial search effort, indicated witnesses had told investigators Nolan had been drinking heavily with friends that day. That detail comes from an early search document, not a confirmed toxicology finding, and should be understood in that context. Nolan's phone, recovered separately from him, surfaced in the possession of a friend. Both his Snapchat accounts were found empty. Following a meeting between the family and the district attorney's office in mid-July, both sides agreed to a joint, simultaneous forensic inspection of the device. Nolan was laid to rest on July 20th. In his eulogy, Reverend Al Sharpton spoke about the inconsistencies and unanswered questions surrounding the case, while explicitly declining to prejudge it in either direction. That's the full picture, start to finish, through the developments we've covered today. Here's where this case actually stands. No official cause of death has been confirmed by either autopsy. No charges have been filed against anyone. What's changed this week is significant. A formal legal step toward possible civil litigation against Nolan's friends and their families. More detailed, but still inconclusive findings from the family's independent autopsy. A direct on-record dispute over how his body was found. A district attorney publicly defending her office's standard process. A reward now at $125,000. And a state attorney general warning against threats to the investigators themselves. We'll keep covering this exactly the way we have from the beginning, as it's confirmed, not ahead of it. Subscribe if you want to be here for whatever comes next.